still have one of those killer's phones that we have not been able to open. Right? It's been over 2 months now. We're still working on it.
And that's FBI Director James Comey talking about the iPhone of one of the San Bernardino shooters. Now, a judge has just ordered Apple to open up the encrypted iPhone of Syed Farouk, part of the couple that was killed by police after 14 people were shot dead by the couple a few months ago. Now, the government says it needs to unlock the phone to investigate the case and possibly to catch other terrorists. But Apple says this would set an incredibly dangerous precedent for anyone who has a phone, which means just about everyone. This is part of the tech giant's statement. Quote, "The implications of the government's demands are chilling. If the government can make it easier to unlock your iPhone, it could extend its breach of privacy and demand that Apple build surveillance software to intercept your messages, access your health records or financial data, track your location, or even access your phone's microphone or camera without your knowledge." All right, a lot to sort through, and to help us do that, we're joined by Darren Hayes. Darren's assistant professor and director of cybersecurity at Pace University. All right, before I get and drill down too much in this, Darren, pick a side. Are you with Tim Cook here or the FBI director? Who's more right in this argument?
I think the FBI director is, definitely, because all that law enforcement and the FBI are looking to do is for Apple to generally revert to the system of key management they had before. What this means is, up until about 1.5 years ago, the government was able to send a phone with a warrant and a court order over to Apple, and Apple would comply with that judge-approved court order and warrant and gain access to the phone and provide law enforcement with that assistance that they need. I think that the argument about this is, goes against privacy doesn't seem to hold much credence, because I don't think that Apple are collecting less information than they were previously. They actually thrive on collecting personal information, just like Google, just like every other company that are involved in data mining. So also the idea about healthcare records, a warrant will always trump your privacy with regards to HIPAA compliance and with regard to healthcare records.
To the argument that Tim Cook makes about the unintended consequences, I'll read one more part of his letter where he said that to comply with the ruling, Apple will have to rewrite its iOS operating system, but once Apple gives special access to one person or group, in this case the FBI, it will have to give access to anyone. He's got a fear of a back door, that once you open it, you can't close it, Darren. Is he right that just because a warrant may compel it here, once you basically deal with this encryption or break through the encryption, then anybody else can follow if they're smart?
Well, Apple used to facilitate law enforcement investigations until they decided to put these encryption keys directly on the device, thereby pushing the onus on the owner of the phone and law enforcement. So does that mean that up until 1 year ago, Apple had poor encryption and a poor way of protecting privacy on the iPhone? I don't think so. I know so. And so I don't think it's a particularly good argument that Apple is making here. And Apple, as we all know, hasn't really given anything up to law enforcement, to intelligence agencies, without the presence of a court-approved warrant. So I don't think that there should be any concern from consumers here.
It's clear to Darren that, and I've spoken to other people, especially in the legal profession, that the law hasn't caught up with technology, at least as to where we are right now. And there's that one clause as to reasonable technical assistance. That's what the judge said that Apple had to provide to the FBI. Reasonable to one person isn't reasonable to another. Are we at the point here where the law has to clearly clarify much more than it currently does where the limits to privacy and protection are?
Yes, absolutely. So congressional legislation needs to be updated. It needs to basically push a lot of these smartphone manufacturers to be able to facilitate law enforcement investigations. We've had CALEA for a number of years, which is the Communications Assistance Law Enforcement Act, whereby telecommunication companies have to design their telecom infrastructure to facilitate Title III wiretaps. And that's been going on for many, many years. The problem is that with the changes in encryption and with the changes in encryption key management, it makes it a lot more difficult for law enforcement to do their job in the presence of a warrant. I think one of the scary things about this is that those in law enforcement that I know who do a lot of mobile phone forensics, and I do a lot of mobile phone forensics, most of the cases are about child abusers, and getting access to that phone and the incriminating evidence is really, really vital. And I think if people thought more about the types of crimes that were being prosecuted, they might think differently about Apple's response to the government.
And just to explain that a little bit further, Darren, talk about what I think is commonly referred to, at least in the industry, as the dark web. There, people are using encrypted apps, whether it be for terroristic purposes or sometimes as a release with child pornography rings. There's a sophistication that they're doing for communication that isn't as simple as you get a warrant or you put a tap on, you find everything. It's more complicated than that, right?
It is, absolutely. Encryption has been a big problem in general, and third-party applications are a different discussion and a different argument, because we have to think about, if we can get access to the phone and people are using these encrypted applications, you know, what should we push these marketplaces of these applications to do in terms of encryption? So that is an important discussion to have. I think the problem in this case is that there hasn't been any kind of productive dialogue between Apple and the government.
Yeah, and certainly, as we saw even with the phone companies in not too recent years, anybody who was seen as being too participatory with the government was answering some obvious questions about privacy, customer infringement rights, etc. But I have a feeling this is just one of many conversations we're finally having in this country as to where those limits are and what we should also expect in terms of cooperation for some of these companies as well. Darren, great job. I really appreciate a few minutes. Thank you so much.
Thank you. My pleasure.
You know, we've had this debate before, and as a country at this table, but we've never really had this debate about that line of privacy and protection. But I'm with the guest and I'm with the FBI on this one, because for anyone to ascribe a motive to Apple that they're looking out for you and me is complete BS. They intentionally put in the encryption to protect the data, not because they were looking out for we, the people, or the customers. They were doing it strictly from proprietary basis. They use our data for all sorts of stuff. So for me, again, what we're talking about is they need the password. They got the phone, but without the password, they can't get into basically the history of who these people, these two terrorists who killed 14 people in San Bernardino, who they talked to, potentially other terrorists. This was new encryption that Apple put on. I got no problem with what the feds are asking here.
It's going to be interesting to see where the court goes. I know there's been one ruling that says that Apple should give up the information. It'll be interesting to see how it goes through the appeals process, and I think it's important that it does.
The court deemed it reasonable.
I understand, and Apple is right to appeal, however it's finally adjudicated, it might go to the Supreme Court. Apple has to abide by that once it's all cleared. But I don't mind Apple going through this process, at least right now. And here's why. Because give me your iPhone and let me look through every bit of information and let me broadcast it out on the air right now. Every email you've sent, every text you've sent, that's the door that this opens.
No,
that's the door that this opens.
It does not. You heard the guest say it too. They have to have a warrant. They have to have reasonable cause here. We have reasonable cause. These people killed 14 people. I want to know if there's any other threat to somebody else. I understand the slippery slopes, but at the end of the day, there is a warrant. It's not like they're grabbing willy-nilly our phones and going through our search histories. That's not what's happening here.
I don't even see it as a slippery slope. Apple does a majority of its business here in America. Security for Americans trumps all of that nonsense about protecting the security code to get into the phone. You got to adhere to what the court says. Let me give you an example. In Europe, when the court ruled against Google, what did Google have to do? It had to adhere to the rules in Europe. So the courts have spoken. As you said, they can appeal, but as you said, there's a warrant. So you don't get to write your own rules in this country. I don't care if you're Apple or not.
But because
it's simple
we
as
haven't
that.
been through this before, the lines of what exactly is allowed, when should Apple have to turn over that information, when shouldn't they have to, that needs to be codified, and that's something that needs to go through a judge to find out when it's appropriate. Look, in the abstract, I think in this case you're right.
Okay.
I think in this case, yes. I mean, look,
It's
you've got a
reasonable,
dead
right?
suspect, so it's not
Right.
like his rights can't be violated. And I think eventually Apple will be compelled to give that information. But I want to see those rules, and I want to see it clarified, because otherwise I know you don't like the slippery slope argument, but there's a reason why people want their stuff encrypted. Nobody should have their stuff and have the company able to open it up at any point.
I just don't want anybody at home to ascribe Mr. Cook and Apple some holier-than-thou motive that they're looking out for our protection. Please, okay? They're looking, as they should. They're looking at their bottom line and what they can do. But at the same time, they use our data all the time, every day, on how to
agree to that. You agree to that in some of the terms and conditions and some of the apps that you opt into. You agree to let Apple do that. You do not agree to let Apple share your information with the police when they ask for it.
However, we do agree, by being citizens in this country, that there are rules and laws that we all abide by, and that we all, for the common good, in this case national security, when we go through the proper checks and balances. And I'm with you. Government doesn't get to, law enforcement doesn't get to kick down our doors in the middle of the night just because they want to. You need probable cause. You need a warrant. They did it in this case, and still Apple's saying, sorry, we're not going to encrypt. Like we say, film at 11, we'll play this thing out. All right, coming up next, we're going to take a look at the race to the White House. Two huge contests coming up, as you know. Will Hillary have to switch things up to take Bernie down? Talk about that, and on the other side as well.